I'm not sure if, like, I know many people are aware of how like the lockdowns and restrictions and all that are like violate people's rights and all that, people's charter rights, like how it's an infringement on people's rights and all that, like these lockdowns and restrictions. So, but I think another thing that's not like being talked about is like is is if whether yeah, like um another thing that's or one thing that's not being like talked about is whether like whether people are getting like proper legal advice, like in regards to um um like what their rights are, like in regards to these restrictions and all that, like whether they're getting like proper legal advice, or like what, or if it's poor, or if they're getting or bad advice. So because I don't think like many think like a lot, they don't know what their rights are. So like especially now with these lockdowns. So as I guess many yeah, as I guess a lot of people know that it's like violation of the charter and all that. So I'm gonna pull up an article right now. So um, so this is an article from Rebel News. It says Canadian civil liberties for the freedom movement, paralegal on the Charter of Rights. It says, as a former prosecutor turned paralegal, Suzanne Coles had concerns that people were being misled legally and that this misinformation would cause a ricochet effect for poor precedent setting and bad law. Be a former prosecutor. So yeah, so she's someone I guess that has a lot of like experience in the legal system and all that. So and yeah, I think yeah, there's a video here of the interview, but well, first I'm gonna read like the rest of the article down here. It says, in light of COVID-19 pandemonium and throughout the freedom movement, there has been an onslaught of poor legal advice being given to both individuals and businesses. While every check and balance meant to be in place to prevent unjust civil liberties infringements has failed, it is equally as disheartening for those with knowledge of the law to listen to inadequate and, in some instances, dangerous legal advice being given to the general public. Feeling ethically compelled to correct this misinformation is exactly why Suzanne Coles began to speak up at rallies and protests. As a former prosecutor turned paralegal, Suzanne had concerns that people were being misled legally and that this misinformation would cause a ricochet effect for poor precedent setting and bad law. She now dedicates her time to helping people navigate the legal system and has been trying to dispel the poor advice that is circulating throughout the freedom movement. Her hope is to educate and inform others on how to adequately challenge legislation that violates charter rights with integrity and professionalism. During our interview, Suzanne and I discussed the Charter of Rights and Freedoms and how the Bill of Rights does not supersede it. She helps to make sense of what the Ontario Human Rights Commission is really for, while clarifying what notices of liability can and cannot do. Okay, so that's the end of the article, but now I'm gonna yeah, I think it's gonna be like a little bit of 25 minutes long videos, so I'm gonna play the video right now.
So let's, for example, refer back to the restaurant and they're being told they can't come in because they're not vaccinated, or they can't get into the store because they're not wearing a mask. They're very quick to want to suddenly go after the individual, the waitress, alleging that she has breached their charter rights. She has not. She's merely the enforcer, albeit inappropriately, in my opinion, but she's merely the enforcer of the law. It's the law she's enforcing that is breaching your charter rights. We're very heightened right now with emotions. We're angry, we're afraid, we're upset. You know, we're losing our jobs. We can't access public places that we used to access. And I totally understand that the level of emotions is very, very high, probably higher than almost any other time in history, save World War II, perhaps. And people, they want remedy, they want it fixed now. There's and unfortunately, if you go into the court of law, if you start proceedings based on your emotions, you're not likely to be successful. The court is not there to assess your emotions. The court is there to assess fact. If people wish to be successful, if they wish to have a strong case, they need to make sure that the facts are gathered to support the allegations. They need to make sure that they keep their emotions outside of the courtroom, and they have to deal with it from a logical, reasonable perspective with facts to support the allegations.
For Rebel News, I'm Tamara Ugolini, and in wake of so much awful legal advice being given out to the general public, I wanted to seek some clarification from someone who has a duty and responsibility to uphold legal ethics. As a former prosecutor turned paralegal, Suzanne Coles wanted to represent the people instead of the government. And in this segment, we are going to discuss proper interpretation of the Canadian Charter of Rights and Freedoms, the correct use of the Bill of Rights, what actually constitutes as a complaint under the Ontario liability are not a fail-safe for backpedaling unjust legislation, ultimately awful legal misinformation being spewed by individuals who are potentially setting themselves and thus others.
A licensed paralegal, as you indicated, with the Law Society. I was practicing in defense for about 6 years, and then I transitioned over into prosecution, and I've been prosecuting for about 5.5 years, almost 6 actually. And I'm now back doing defense again. I was put on unpaid leave from my employer as a prosecutor at beginning of September due to the request for medical information related to the vaccine policies initiated by my employer. I was then terminated at the end of October. In the interim, during that time when I was on unpaid leave, I was attending a number of local rallies related to vaccine mandates and policies. And I had noticed that there were a number of people who were referring to or giving very inaccurate legal information, and it was becoming very concerning to me. So I was at one of these rallies, and I had had a little discussion with one of the organizers and had asked if it was possible just to speak briefly. To be quite honest with you, I'm not particularly comfortable with public speaking, but I have a duty as a licensee to make sure that people's rights are protected. I took an oath to stand up and protect people's rights. But I also, part of that oath is to make sure that when there's inaccurate information that could potentially lead people into very dangerous waters within the judicial system, that I correct that to the best of my ability. So this organizer thought, oh, great, yes, get up and speak. So I got up and spoke, and things have just snowballed out of control since then.
Can you clarify for our viewers what you presented over the weekend at an event that I was an attendee of, in terms of the Bill of Rights and how that does not supersede the Charter, as has been hinted toward by various groups and people, again, giving this legal advice incorrectly?
And when we look at the Bill of Rights, which was enacted in 1960 by John Diefenbaker, that was pretty significant at the time, and that came out of the Constitution Act of 1867 as well. That was adhered to and that was followed. But what's interesting is the Bill of Rights between 1960 and 1982 was relied upon by 36, I believe it was 36 cases when it came to constitutional issues. And only one of them, the Dry Bones case, actually resulted in the changing of the law. In all of the other cases, the Bill of Rights had no teeth, so to speak. It didn't impact enough to have any changes made to the law that was challenged in any individual case. Then in 1982, Pierre Elliott Trudeau, as part of the Constitution of 1982, brought in the Canadian Charter of Rights. So because that was brought in 22 years later, and is the most recent in relation to the understanding and the guidance for our rights, that would become the one that has superseded and is therefore the one that needs to be relied upon. The Bill of Rights still exists. The Bill of Rights at this point, if it's used in a court of law, it's generally used perhaps as a guidance. They might reference it just to get some, guidance from previous court cases, which are called precedents or common law. But generally, it's not applicable. If it is applicable, it would be only to federal law. So that's law made by the legislature of the Government of Canada. Any laws made by provincial legislators are not bound by the Bill of Rights. It's the Charter of Rights that applies. And that's very clearly set out in both of them. In the Bill of Rights, it makes reference to this law applies to the laws of Canada. When you look at the Charter, it makes reference to the laws of Canada as well as the Northwest Territories, the Yukon, and all of the provinces. And the reason that the Bill of Rights does not apply to provincial legislation is because the provinces never signed off on it and gave their okay for it. So it's not binding on any of them. So that's really significant. In the landscape that we're facing right now, other than any federal laws, which there really are very minimal amount, related to any COVID policies or mandates, those are primarily related to travel. So if you're traveling by airplane, by boat, or by train, then yes, the Bill of Rights may apply, although I would suggest the Charter would be more applicable. It's definitely more vast than the bill. But if you're dealing with provincial, you need to refer to the Charter. And everything we're dealing with, whether it's an employment issue under the Employment Standards Act, which is provincial legislation, the Workplace Health and Safety Act, which is provincial legislation. If we're dealing with the Health Promotion and Protection Act, that's provincial legislation. So all of the things that are actually setting out the COVID issues that we're dealing with in society now all fall under provincial legislation. And so that's where we have to look at the Charter. Part of the Constitution of 1982 was the severing of Canada from the British monarchy as far as the writing of our laws. And so when the Charter received royal assent, it actually occurred in England. And there's actually ways to find that. I certainly could provide some of that. If you look, the word is Hansard, Hansard. So all governments are recorded. Any debates or any discussions within government is recorded, and those are called the Hansards. And all governments have a record of those. And it's very easy to go into any government website and look for the Hansards. And you can certainly find the Hansards where the discussions and the royal assent occurred in England related to the Charter of Rights and the Constitution of 1982. So if people are looking in Canada for that royal assent, they won't find it. It didn't exist here. It occurred there.
Talk to me a little bit about what you presented in terms of the Ontario Human Rights Commission and how certain things like masking or enforcement of the vaccine passport isn't necessarily, there's no fail-safe within the commission for something like that.
Okay, so the Ontario Human Rights Code does protect under certain recognized groups, and they're specifically set out in the Human Rights Code. So for example, you're protected for religion or creed, you're protected for marital status, you're protected based on your gender, you're protected based on any disability, you're protected based on color. So, but they're very specific. So when it comes to masking, for example, that's not a protected group within the Human Rights Code. There's nothing that has that in there that's a specific right. And I'll give you an example of where it's very defined. So if somebody of color, for example, went into a Walmart, or whatever store, I'll just use Walmart. If somebody of color went into Walmart and the store manager said, "We don't serve your kind, you need to leave," then certainly that's a significant human rights infraction. Or if somebody was disabled and was trying to enter the store, but there was no ramp, and was trying to seek assistance to get into the store and was told, no, we're not helping you and we're not putting a ramp in because we really don't want you here. That would be a significant human rights violation, because it's targeting specifically for something related to that individual that's recognized under the code. But there is nothing recognized under the code in regards to masking. So if somebody went in without a mask on and was told to leave, there's nothing to protect them under the Human Rights Code for that. Mm-hmm. And certainly the thing that people need to remember is, even if an establishment is open to the public, it's still an establishment where the owner has the right to prohibit entry for any reason to anybody. So if they've told you to leave and you're not leaving, then they certainly have the right to call the police to seek assistance with that. And if they've told you to leave and you're refusing to, you do then run the risk of being charged with Trespass to Property Act under provincial legislation, because you're there after you've been told to leave. Yes, if you have a disability that's preventing you from wearing one, yes, you potentially do. But the situation would also you'd have to bring up within the Human Rights Code or the hearing, you would have to provide proof that there actually is a disability, versus going in there saying, well, I have a medical exemption, and your medical exemption is, you just don't like it. Right. So you'd have to show that there's actually a disability that's preventing you. There's also then, you'd have to be able to show that you were targeted because of that disability. So it would be challenging with people who are going in and just filling the Human Rights Commission with frivolous applications. It does muddy the water, and it makes it even more challenging for people who actually have legitimate human rights applications that need to be dealt with. And what people need to understand as well is the concept of precedence. It's also known as common law or case law. And that is prior decisions that have been adjudicated in court. And there's a hierarchy of the way the court system works in Canada, the same as the police system. You have the lower, the middle, and the upper. And when you get to the decisions from the higher courts, like the Supreme Court or the Superior Court, for example, they become binding on all the lower courts. Within the lower courts, it becomes what's called persuasive. So a decision in Toronto could be very persuasive to a decision that a justice is potentially making in London, let's say. If it's based on the same set of circumstances and the same type of facts. And it becomes very problematic when people are doing frivolous court cases, or they do not know how to properly argue court cases. They do not perhaps know what kind of evidence needs to be put forward to the court in order to support the situation, that you get bad cases that are adjudicated, and then they potentially could be relied upon, which then puts cases that could be, a good case, then it sets them up potentially for a bad decision because of prior case law or precedents. It's something that people need to be very mindful of when you go in doing frivolous cases like that. The Charter refers to laws. It has jurisdiction over laws. It does not have jurisdiction over individuals or businesses. That falls under the Human Rights Code. And people are mistaken when they're thinking that they can, if somebody gives them a hard time. So let's, for example, refer back to the restaurant, and they're being told they can't come in because they're not vaccinated, or they can't get into the store because they're not wearing a mask. They're very quick to want to suddenly go after the individual, the waitress, alleging that she has breached their charter rights. She has not. She's merely the enforcer, albeit inappropriately, in my opinion, but she's merely the enforcer of the law. It's the law she's enforcing that is breaching your charter rights. And one of the examples that I've used in my speaking engagements, and I'll refer to it now, is they're simply just following the law as it's written. And as long as the law is still in place and deemed valid, it can be enforced. It's only when a court determines it to be of no force and effect that it's no longer can be enforced, or when the legislature rescinds the law. Those are the only two ways you're going to get rid of it. Individuals cannot unilaterally decide that the law is no good and doesn't apply.
And so, if I gather what you're saying correctly, we must challenge these laws properly and with good due process. And that's not a quick, easy task.
That's very correct. And no, it does take time. And I realize that people we're very heightened right now with emotions. We're angry, we're afraid, we're upset. We're losing our jobs. We can't access public places that we used to access. And I totally understand that the level of emotions is very, very high, probably higher than almost any other time in history, save World War II, perhaps. And people, they want remedy, they want it fixed now. There's very little room for patience anymore. And unfortunately, if you go into the court of law, if you start proceedings based on your emotions, you're not likely to be successful. The court is not there to assess your emotions. The court is there to assess fact. If people wish to be successful, if they wish to have a strong case, they need to make sure that the facts are gathered to support the allegations. They need to make sure that they keep their emotions outside of the courtroom, and they have to deal with it from a logical, reasonable perspective with facts to support the allegations. If they go in stomping their feet and screaming, "I don't like this," they will fail. That's inevitable.
Yeah, and on that topic, let's just switch angles to talk about these notices of liability. And so I've seen a lot of people, and parents in particular, on social media who have clung to this notion that this notice of liability, and if they serve the teacher that's enforcing masking of their child, or the principal or the superintendent, or their employer with these notices of liability, that'll be their fail safe to backpedal and rein some of these restrictions in. But that's not necessarily the case. Can you clarify for us?
A notice of liability is just putting the individual that you're serving on notice that if you should suffer any financial losses, physical losses, psychological losses, that they will be potentially held liable to cover those losses for you. That's basically what it's doing. When the notices of liability were first coming out, when it was realized that we were going to start losing our jobs, it was hoped that it would cause employers to backpedal a little bit and maybe reconsider these policies that they were enacting. But obviously that hasn't been successful. But the notices of liability from a work perspective, and I'll refer to your reference in a moment regarding the parents, is simply to pad your case, to give yourself a stronger case going forward into a civil court on an application for wrongful dismissal, for example. But when it comes to, for example, filing a notice of liability to your teacher, so you're notifying them that they're going to be liable for any monetary losses. Well, what monetary loss, if you decide to take them to court, are you going to be out because they're telling your child to wear a mask, or they won't let you in the arena, so you have to sit in the car and wait for your son to finish playing hockey? What monetary loss are you out? You'd have to prove that. What physical loss have you engaged or endured because of that? Or what physical loss has your child experienced because of that? There might be some, but you'd have to have that proven medically by a doctor. And you would have to be able to show a cause and effect, that the mask actually caused that physical issue or the psychological issue. I'm not saying they don't necessarily exist, but I think it would be an incredibly high hill to climb to be successful in that. I think there's just been misguidance that the notices of liability are telling them you can't do this. The notices of liability do set out the laws they're breaking. But as I think most of us are aware, if giving somebody notice that they're breaking the law would cause people to not break the law, we wouldn't need police, we wouldn't need court, and certainly I would never have a job. because people would stop as soon as you give them notice. And that makes no rational sense. I mean, imagine walking down the street and somebody's coming up to grab your purse and run away with it. If you turned and yelled at him and said, "You're breaking the law, you're not nice," do you think they're going to say, "Oh, sorry," and walk the other way? No, they're going to take your purse and run anyway, aren't they? And then you've got recourse after the fact, certainly. But that's where the problem is with these notices of liability. Again, it's not the teachers that are the problem. It's the law that tells the teacher to put the masks on the children. That's the problem.
Mm-hmm. Yeah, it really comes back full circle there. And I just want to reiterate for our viewers too, that it seems as though these notices of liability are really an empty threat unless you are prepared and willing to go that next step, which is litigation.
Yes.
Yeah.
Yes, absolutely. And if people have a legitimate case, and they should have that reviewed by a legal professional, and certainly if it's more than a $35,000 claim, for example, it's a termination of employment, and you're looking to sue for a significant amount of money, then yes, you would have to retain the assistance of a lawyer. If it's less than that, you may be able to retain the assistance of a paralegal. The public should be aware that paralegals can represent in civil court, but only in small claims court, where the maximum amount in a claim is $35,000. So they have to assess that. But if you have a legitimate claim, you certainly should be pursuing it. You have the right to do so.
Mm-hmm. It just might come at some cost and be long and drawn out.
It could potentially. But I think what people need to be aware of as well is that time actually has been on our side. And I know people are frustrated and want things to happen now. But if we looked back even 6 months ago, and what the climate was and the information that was available at that time, actions that were filed 6 months ago were much less likely to be as successful as the actions today. Because 6 months ago, we didn't have the proven medical information that the vaccine efficacy is 30%, 40%. 6 months ago, it was 90%. So if you went to court to claim that it was against your rights to be forced because it's not really protecting anybody in the public, you probably wouldn't have been successful, because all the evidence was showing at the time that it was 90% efficacy. Now we can say, why are you making me take this if it's only 30% efficacy? It makes no sense. 6 months ago, there was no evidence, legitimate evidence, that those with the vaccine were spreading it at or at a higher level than those who are unvaccinated. Now we have that. So with each passing day, there's more evidence that comes out that actually is going to be beneficial to those people who have suffered because of these policies and mandates. So it has been on our side, because each little bit of information is giving us stronger case. We are all challenging the false narrative and the false information related to medicine, and the false information related to this vaccine that has promoted these vaccine policies and mandates that are very dangerous. And we're all well aware of the amount of people who are dying and becoming disabled or suffering lifelong serious illness because of this. The same thing goes with law. And I'm now seeing, as I'm sure a number of other legal professionals are seeing, that there is false information related to legal principles and the understanding of the court process that is being put out there that people are relying upon. And relying upon that false information is just as damaging potentially as relying on false medical information, because you're setting yourself up to failure and potentially losing a significant amount of money. Potentially losing, because you're losing money, you could lose everything you own. You could lose part of your reputation. I mean, there's a lot of ramifications to having bad legal advice. And what I would like people to remember is, just as when you go to a physician, if you kind of don't feel right about what they're telling you, get a second opinion.
Suzanne Coles cuts to the chase. She delivers clear and concise information and does it with integrity and merit. Please share this video with your friends who may be under the influence of homemade lawyering or may be given wrongful interpretations and bad legal advice. In a world rife with misinformation, let's do better to prevent that in the legal world, because it is more important than ever before to dot our I's and cross our T's. For Rebel News, I'm Tamara Ugolini. Here at Rebel News, we know that many of the checks and balances meant to be in place to prevent unjust legislation from infringing into our daily lives has failed. And it's why we've launched the biggest civil liberties initiative and undertaking of our time, fighting vaccine passports. And we're doing it using qualified, experienced professionals with proper legal process. To help us in this effort, please consider donating to crowdfund individuals' legal defense at fightvaccinepassports.com. Your donation goes directly to the registered charity called the Democracy Fund, where legal defense is again crowdfunded for people who may not otherwise be in a position to hire their own legal defense. Consider donating if you're able to at fightvaccinepassports.com.
All right, that was the end of the video. Yeah, it was it was a little lengthy, like the video. So, but yeah, like, yeah, as like Suzanne Coles said, like, people are being given bad advice, and like she wanted to, make sure that like people weren't being like being given misinformation or like bad legal advice. So like, yeah, she became a paralegal to help people like navigate the legal system and all that, and give people like actual proper like legal advice. So yeah, like most of what she said, I think, like, yeah, like, I don't I don't thoroughly like, yeah, I mostly agree with what she was saying in the video. I think the only part like where maybe I was sort of the only part where I was sort of like disagree with her is like where she talks about like the whole trespassing thing, where like when you enter into an establishment, all that, like it's automatic, like you're considered to be trespassing if the owner or manager, whoever, doesn't want you like on the property. So yeah, like, I think aside from that, like everything else she said, like, yeah, like it sound like, yeah, pretty much like sound logical and all that. And yeah, like the Bill of Rights, she also said like how the Bill of Rights only applies on the federal level. So I guess, yeah, as I guess, a lot of Canadians are being told that, or they're being given like bad legal advice, that the Bill of Rights applies to, I guess, provincial level too, but it actually only applies to the federal level. So like the Charter of Rights and Freedoms is that's what applies to like both federal and provincial levels. So yeah, like that's what people have to use, like, in terms, yeah, like if they want to, like, I guess, challenge a government and all that on like infringing their rights and all that. So yeah, like the only part where I didn't like really, yeah, the only part where I guess sort of guess like didn't really like, or like I sort of like disagreed with, is where she talks about like the whole trespassing stuff, where she says like how the owner or the manager, whoever, of the establishment can like, I guess, yeah, like how they can charge you with like trespassing or something like that if you enter into the establishment, like even like during business hours and all that, like because the establishment is open to the public. But apparently, like if you don't have like a job passport, or if you don't like if you're not wearing a mask, then apparently like the like the owner or whoever, the manager, can apparently like trespass you or accuse you of trespassing or something like that, which to me, like, I don't really understand, because if you're there, like if you're there to buy, like if it's a restaurant, for example, and if you're there to buy something like everyone else is, then I don't see why, like I don't see how that's considered trespassing, unless you were to like unless you were to enter the place like during non-business hours, like like if someone like breaks into the place, like a robbery or something like that, like a robber. So yeah, like the whole trespassing stuff, I'm not like really getting that, and yeah, like yeah, that part didn't really like understand, and but yeah, like aside from that, like everything she said, like it all like made sense and sounded pretty logical too. So yeah, and yeah, she also mentioned how like I think the like like when it comes to filing complaints and all that, like if it's against a business, then you have to go to the Human Rights Commission. And that if it's, I guess, again, if it's against the government, then it's like a charter challenge or something like that. So yeah, yeah, basically, yeah, like I think aside from the whole trespassing stuff, what she said pretty much sound like logical and all that. So yeah, I can close that now. So yeah, I know that was like a long video, and yeah, and I hope that helps, Canadians, or yeah, like I hope it helps Canadians with like what their rights are and all that, in regards, like terms of like like in terms of like these restrictions and all that. So yeah, like because as Suzanne Coles said, many Canadians are being given bad legal advice and all that. So I hope that video helped, like, and helped Canadians with like knowing what, or like better understanding what their rights are and all that, and like understanding like the difference between the Bill of Rights and Charter of Rights and all that. So yeah, that's everything I want to talk about. I'll be signing off now.